Bismillahirrahmanirrahim. In this discussion, we shall put before you Lecture 7 of International Law. It is Lecture 7, Chapter 3, Question 2. The question is, does the customary international law grant the right to use of force a state in response to terrorist attack on it? Substantiate your answer by arguing from Article 51 and Paragraph 4 of the Article 2 of the United Nations Charter and other recent examples in this regard. The same question was in CSS exam 2012. Intro of this lecture, this question, customary international law. Customary international law grant the right. What is customary international law? Customary international law consists of rules and principles evolved and developed of practices and usages accepted as customs by the state while regulating relations with each other. There are four things. One is the custom, second one is habit accepted, and third one is usage. All these are the customary rules which were evolved and developed by the states while regulating their relations with each other. And under customary international law, the state has a right to answer the attack or right to answer the interference in its affairs. And the same principle was recognized in Caroline case in United States when the Britain attacked American ship which was helping the Canada while during war of Britain and Canada. Definition of international law, the definition by Charles Hyde, definition by Oppenheim and Stark. The definition of submitted by Professor Stark is a very comprehensive and compact, which means the set of rules which regulates the relation between states, interstates, intrastates, relations between states and international institutes, between individuals, multinational companies. That set of rules called the international law. Customary rules of international law. Again, the customary rules and principles are the major part of international law. These rules had been evolved during the course of history after the long process and their recognition by the international community. International customs are the important source of international law. It has been recognized by Article 38 of Statute of International Court of Justice as main source of international law. According to Winner's abridgment as held in Tanstray case 1608, a custom in the international law is such usage as had obtained the force of law. What is paragraph 4 of Article 2 of the United Nations? In simple words, according to paragraph 2 of Article 4, no state can use force against the other state or interfere in the affairs of other state. It is general rule. But there is one exception, and that is Article 51 of the United Nations Charter, which is exception to paragraph 4 of Article 2, which provides a state to answer or interfere in the affairs of other state in three situations. First one is actual armed attack, and the second one is principle of necessity, and the third one proportionate use of force while the other state is acting or using force against the other state, and the second state has also right to use the force in a proportionate manner. Use of force under the customary international law, as already explained, that the same principle was recognized in Caroline case. The situation was that in the caption case, the Britain forces were entered in the US territory and destroyed the ships which were supplying weapons to the Canada against Britain. The same was declared lawful by the American court. The act of Britain forces who destroyed the American ship was declared lawful by the American court, as a rule of customary rule of international law, while they use force against the ship, against the state which was helping enemy country. Use of force respond to terrorist attack. It is a debatable issue, still debatable issue, and still debatable question. When a terrorist attack to a state, can the state which were victim, which were attacked, has a right to response to the terrorist? It is debatable issue, but in recent past, in first decade of 20th century, the example of American attack on Afghanistan, American attack on Iraq, American attack on Libya were the example where the terrorist attacks were answered by a state, but still there is no final principle or established rule that the force can be used against terrorists. But by practice, it has been established that the victim state can use force against the terrorist. Thank you very much. And the next lecture we shall continue the same question in detail.